officers present as well, let the record reflect. I have read and reviewed the probation report prepared for this matter, but also read and reviewed a motion for new trial alleging a couple of bases therein, in addition to an argument that's made in the sentencing brief on behalf of the defendant regarding the verdict in this case. I'm prepared to address those issues at the outset, of course. And with that, Ms. Osby, as relates to your motion for new trial, any additional comments you'd like to make?
Well, Your Honor, the basis, obviously, the predominant basis of the motion for a new trial is that it is the defense's contention that Dr. Abrams should never have testified in this case against my client. And the mental health of my client was not a subject that was raised by me. By having Dr. Abrams testify, it was extremely prejudicial. The people have responded by saying that it wasn't character evidence. It was nothing but that. Since he was unable to interview my client, he gave his own opinions as to what sort of person she could be, which would lead the jury to believe that she was mentally ill, and potentially because of that, somebody who could have engaged in this sort of heinous act. And I feel that the court was in a position where it was impossible to weigh her rights versus Mr. Patton's client's rights. And since Mr. Patton filed all of his requests under seal, it did not become apparent to us until the actual opening statements on September 14th that his client was going to step up and say that he had nothing to do with it, and that my client was the one who had somehow come in the house and killed Ms. Killgore. And the severance had been denied on August 7th. The records that Mr. Patton kept asking for and did not receive, and I did not believe he would ever receive them since I had not put her mental health in issue, was not until August 25th. So because of that, I feel that the court was in an impossible situation in order to give Mr. Patton's clients the right to a fair trial and my client a right to a fair trial, and I feel that my client did not therefore get that, and I think there should be a new trial.
All right. Thank you, counsel. On behalf of the people.
Your Honor, the people have outlined their arguments in their moving papers, but essentially it's the people's position that the court had more than enough information to make an informed decision. The court, I think, spent a great deal of time, first in the 402 hearing and then hearing the respective arguments of counsel in substantially limiting the testimony of Dr. Abrams, and obviously in making that determination found that the testimony was going to be only offered for the limited purpose, and I don't believe character evidence was implicated based on that limited testimony. In addition, the court also had more than enough knowledge to determine whether severance was appropriate in this case, and obviously the court found that it wasn't. And so with that, the people submit that the court did not make any mistakes or errors as a matter of law, and therefore the verdict should stand.
All right, thank you. Ms. Osby, any additional comments you'd like to make at this time?
Submitted.
Well, there are essentially three arguments placed before the court as it relates to the prospect of a new trial. Now, Penal Code Section 1181 addresses the appropriate bases for new trial, and here the argument that's made essentially is that there was some error as relates to a question of law. I have in the past made an extensive record as relates to the admissibility of Dr. Abrams' testimony. I'll address that again momentarily, but I don't intend to address it at this time in great detail, at great length, given the prior ruling of the court, the record that has been made. In addition, the issue is raised as relates to the propriety of a severance motion. I'll address that again momentarily. And then separately, in the defense moving papers related to the sentencing, in this case, the sentencing brief, an issue is raised as relates to the propriety of the verdict. And I'll address those three issues together at this time. First, as to Dr. Abrams, his testimony was limited as articulated by the people, and I believe under the circumstances that the testimony that was permitted was appropriately permitted in this case, that the appropriate limitations were imposed as relates to Dr. Abrams' testimony that permitted Defendant Perez to place before the court an issue deemed significant to his defense, and that in the end was not overly prejudicial to Ms. Lopez. There was much other evidence placed before the fact finders relates to Ms. Lopez's mental health or state of mind at the time of commission of the offense, which of course included the 7-page letter that's been referenced in a variety of ways as a suicide letter, as an exoneration letter, and the like. Each defendant, of course, was entitled to a defense in this case, and to the extent that defenses may have been deemed inconsistent, each with the other, at odds with one another, that would not and did not necessarily require a separate trial as to each defendant. This was a case wherein there was much cross-admissible evidence to be considered by the court and ultimately the fact finder that related both to relationships amongst the three individuals tried, as well as relates to the facts and circumstances surrounding the crimes. In the end, no severance was sought by Ms. Lopez, and there had been notice, significant notice, as relates to the intentions of Mr. Perez to at least endeavor to place Ms. Lopez's state of mind in issue. No request was made for more time or a continuance in this matter. We all set a hearing date as relates to 402 hearing regarding Dr. Abrams at a time and place convenient to all during the course of the trial. Now, it is true that we did not know for certain what Mr. Perez was going to say until he testified. We certainly had significant preview of that given during the course of Mr. Patton's opening statement. Given the limitations the court imposed as relates to Dr. Abrams' testimony, I don't believe that Ms. Lopez was prejudiced. Calling an expert to counter what Dr. Abrams had to say, it seems to me would have been of little benefit, given in particular the 7-page document. And we must be reminded that the jury did not accept Mr. Perez's account of what took place. It is clear they saw the case as presented and argued by the District Attorney's Office, believed that each participant continued to act in the roles that they maintained, the roles of master, mistress, and slave in this case. And given all of that, and the prior record made by the court as relates to Dr. Abrams' testimony, I respectfully deny the defense motion for new trial. Having addressed that issue, we'll proceed to probation hearing and sentencing unless there's anything counsel wish to address prior to the sentencing in this matter. Hearing nothing. Counsel, do you waive or enter for judgment?
So waived.
Any legal cause?
None.
Ms. Osby, additional comments that you'd like to make?
I would submit on the sentencing brief that I filed with the court.
Thank you. And on behalf of the people.
Yeah, we can submit on probation's recommendation.
Thank you. Anything more on behalf of the probation department?
Probation submits.
Thank you.
Your Honor, I misspoke. There was a request from the rest that their impact statement be read for the court again now that this defendant is being sentenced, and Ms. Mitchell's here prepared to do that.
Okay, very good. She may come forward, and I just remind her to please take her time.
Your Honor, it was springtime and my sister was coming home. I had just got a new video game and it was hard. She was good at video games and I liked to play them with her a lot. Brittany promised to help me with the game when she got home. I was stuck. I love my sister and I miss her very much. I want her back. The people that hurt Brittany are bad and I hope they stay in prison forever. Call and rest. Brittany's little brother. The next is from Daryl Rest. Dear Judge Kirkman, it was January 2012, and we were standing in the Cleveland airport waiting for Brittany to board a flight back to California after a month-long Christmas visit. It was great to have our whole family together again. As I watched her walk away from the security checkpoint down the hall, I had a sinking feeling that I would not see her again. However, that's just the butterflies every parent has when their children leave. I soon dismissed it as silly, irrational emotion and went about my day. A few months later, after much encouragement, Brittany was coming home to stay with us while she worked out a plan for her life. We had spent weeks planning her move, arranging for travel and having her personal belongings shipped. April 15th was the day I would see her again at the airport. Her sister Sabrina, who had become very close friends, as a parent delights in seeing, gave birth to a beautiful baby girl, Sophia Aline, on April 11th. Brittany was extremely excited to get home and see all of us, but especially to meet Sophia for the first time. She had a few things to take care of, a few more days, and she would be home safe. As we now know, that didn't happen. Instead, a few weeks later, we walked into a small viewing room at a funeral home to see a metal shipping casket screwed shut so that it could not be opened. After the trial, we all know why we could not view our beautiful Brittany. Many events imprinted on my memory about our loss, but repeatedly hugging a cold metal casket while trying to understand what was happening will forever be imprinted in my memory. I am given the chance to provide this victim's impact statement on how the loss of our daughter has affected my life. For several years, I have relished the opportunity to provide a statement, spending many hours thinking about what I would say, how I would say it, and whom I would direct it to. Mostly it served as a therapeutic exercise to help me cope with the mental trauma I was experiencing. Now the time has come to prepare the impact statement, and through countless hours of thought, I have come to the only rational and logical statement I can conceive of. No words can ever convey the feelings, emotions, despair, and impact of losing a child in such a horrific manner. It simply cannot be done. Only a parent who has lost a child in such a manner could begin to understand. However I feel as a victim cannot compare to the real victim, my daughter Brittany. Her life was violently and senselessly taken in her prime. I am her father, and as such am supposed to protect her. I failed her. I struggle every day trying not to think of what she felt, what she was thinking. Was she in pain? Was she praying she would be helped? When will it end? Because if I do, I know I cannot mentally survive. I am trapped. I'm not going to go into what a fantastic, caring, loving, funny person Brittany was. Anyone that truly knew her or learned about her during this investigation already knows that. She had a quick sense of wit, too much for some with low self-esteem, an artistic talent, and cutting creativity. She was in the prime of her life, just starting to find herself and think about what she wanted out of life. My heart aches knowing that she will never realize her hopes and dreams, never find true unconditional love, and never experience the joy of having children and seeing them blossom into adults, among many other joys life has to offer. I have spent years trying to find some sense of normalcy, and within the last year, I have learned to function on a minimal level. I know I will never be as I was before, but as long as I do not think too much about Brittany, I'll get by. Psychologically, that is troubling. I do not ever want to forget her, but it pains me to think about her. Certainly, we have been impacted financially by our traumatic loss, but this is the least of our trauma. We can quantify the direct financial losses we have incurred due to funeral expenses and lost wages associated with the legal proceedings. The losses untold are losses due to past and future wages because of the painful loss of our daughter. I was once climbing the corporate ladder as a highly accomplished engineer leader. Now I simply work to survive. I have been unemployed for more than half the time our loss occurred, simply because I cannot focus and perform as expected. The chatter is I am considered a high risk among colleagues and within my field. Time heals all, right? Law provides that the crimes the three defendants were convicted of mandates that they will be in prison for the rest of their lives, never to experience a meaningful, purpose-filled life. Upon reflection, this is sad. However, that reflection is quickly broken and ripples away, like throwing a rock into a still pond. When I think of the senseless, brutal kidnapping, torture, and killing of our beautiful daughter Brittany, such monstrous disregards for humanity and God's creation, then to attempt to dismember what God made and dispose of her as if she was trash. 12 fact finders and the law got it right. I assure you, if there is any possibility that these three will see freedom again, I will be there fighting with all I have to stop it. Please ease my burden. Very respectfully, Daryl Rest. Your Honor, on April 14, 2012, I received a phone call that changed our family's life forever. We looked forward to having Brittany home. Her sister had just had her baby on the 11th. Brittany was super excited about being an auntie and could not wait to meet her niece. Brittany's brother, who was 5 years old at the time, was talking to Brittany about his new Ninja Turtle video game he wanted her to help him with. Britt never got the chance to meet her niece, and Colin never played his Ninja Turtle video game again, eventually asking to sell it. Colin has asked over and over questions that we cannot answer for him. He is too young to hear some of the answers, and others are questions without good answer. Daryl flew out to California on Sunday the 15th to look for Brittany and talk with law enforcement. We had to find out what happened to our daughter. On April 17th, I had to sit down and tell her sister Sabrina that Brittany was found. Then she and I sat down with their then 5-year-old brother to explain the unexplainable. I will forever have the horror on his face and in his voice when he realized Britt was dead and not coming home in my head. I then had to make many other calls to grandparents and many other family members and Britt's friends. I have dealt with so many emotions trying to learn how to live each day knowing not only is my eldest daughter dead, but that she suffered her horrible death. I think how scared she must have been during her ordeal and death, and it still and always will break my heart in a way I cannot put into words. Brittany was just starting out her life. She had turned 22 only 2 weeks prior to her murder. She was in an unhappy marriage that was long over. She was ready to figure out what the next step in her life would be. I mourn all that was lost, all her dreams and hopes, all of our dreams and hopes for her. I miss her laughter and quick wit. I miss that we will not experience another time with all of our family laughing and having fun. I miss that we will not watch Britt and her siblings growing together and Brittany being a great auntie to her niece and now nephew. She would have adored. I and all who truly knew Brittany and loved her are blessed because there is not another out there like her. Brittany has grandparents and aunts and uncles that will always miss her and will forever be affected by her murder as well. She has many friends, some she has known since elementary school, will always miss her. Brittany was very loved by many and always will be. I am glad the three monsters responsible will spend the rest of their lives in prison so that they cannot harm another innocent person. It is hard to quantify by words how this one act has damaged and changed our lives forever. I will never get over my daughter's brutal murder. I will always wonder, what if? I will always wonder many things, and there are 4 people with the answers. My daughter Brittany can no longer answer them, and the other 3 are liars that sat for weeks listening to horrible testimony as we did, and who sat on the stand for 2 days. We saw tears for each other and for themselves, but no remorse, nothing for our daughter, who they all 3 know exactly what happened as they all kidnapped, tortured, and strangled the life from her. These 3 monsters saw her face, saw her tears, cut her, and threw her out like garbage, and sat in jail and in court time after time as if they are victims. Brittany and her family and friends, as well as their families, are the victims of their horrible choices. I thank you for the court's time and ask for the mandatory sentence of life without the possibility of parole for all 3 defendants to be upheld and served. To the 3 that murdered my beautiful daughter, I ask, was it worth it? Was it worth taking my daughter's life and spending yours behind bars? I hope that each day in prison is miserable until you draw your last breath and you are shown the same consideration and concern that you showed to my daughter by your fellow inmates. May God grant you forgiveness, because I cannot. Thank you. Michelle West.
Thank you, Lynn. Judge Williams.
Your Honor, I also have a statement from my client's father that he wishes me to read.
Very well.
Do you want me to stand or shall I sit?
As you please.
This is a statement from Robert Scott Lopez. I want to extend my deepest condolences to the family of Brittany Killgore for their loss and for all of the pain and sorrow that has followed. Parents should not have to bury their children. I can only imagine what they have been going through during this long period and having to relive this tragedy in court. I hope you find peace somehow with the help of the Lord. I am the father of Jessica Lopez, as well as her 3 younger sisters. It was a new and exciting time with the birth of Jessica, which unexpectedly changed to an emergency C-section during a morning shift change. With the sudden births of several babies that morning, I was mistakenly told that Jessica was a boy. A few minutes later, the nurse apologized to me, saying it was actually a girl. She and her mother were doing just fine. She was a wonderful baby and had plenty of love and attention from both sides of the family. Just a year later, we had a second daughter, Sarah. As proud parents, we bought the then popular VHS video camera and captured as much of our daughters' lives as they grew up. We cherished every moment we had with them. We loved the animated children movies such as Snow White, Cinderella, Dumbo, among others. Music was very popular in our family, and I would take each child one at a time to dance, feet dangling in the air as the movie played, and the other girl anxiously saying, "My turn." As they grew up together, we would regularly take them to the park to play and take them for a bike ride with their child seat. As we attended church, our kids would go to Sunday school to learn about our Lord God in a way that made more sense to them. Jessica was always proud to show her mom and me the art projects completed each Sunday. Jessica was always a caring person and would go out of her way to help others, even at an early age. When she was about 3 years old, she and her sibling were riding their tricycles in the garage as I filmed. Sarah had ridden behind the car out of view of the video camera and started crying, unable to turn around in the tight spot to return. Jessica heard her, stopped her bike, and then casually walked around the car to help her sister. Sarah stopped crying, and then Jessica walked out carrying Sarah's tricycle, with Sarah walking closely behind her. Jessica put the tricycle down, allowing Sarah to sit once again. Both continued riding together without further incident. About 8 years later, we were excitedly moving into our new home with a pool in the backyard. As we stood by the wide stairs to the pool, our now 3rd daughter, Erica, at age 2, unexpectedly ran over the steps into 3 feet worth of water. Jessica was the first person to react and jumped into the pool, grabbing Erica in less than 1 second and pulled her out. In junior high, one of Jessica's male classmates was at a San Diego hospital for treatment, and she wanted to visit him in order to make him feel cared about. She was the only classmate to visit him. After high school, Jessica attended college, as well as getting a CNA, or a Certified Nursing Assistant, classes as an introduction to a healthcare professional. Before finishing college, she immediately started working as a CNA instead of the regular teenage jobs she had worked before. She adjusted very well, and she cared for all of her patients and clients dearly while enjoying the positive feedback she regularly received. Jessica finally completed her general education AA degree in 2011 and continued her profession. As teenage life goes on with most, if not all, teens, Jessica wanted to be more independent and test her parents. This is a tough time for parents as children transform from loving, understanding protégés to adolescence. And all parents can do is continue to be caring and offer advice on a casual basis. Once this period ends, the children always come back to their senses and positive life once again continues. During this time, Jessica did not get into tobacco, drugs, or sex like a small population of kids at this stage in life can do. She began playing the flute in junior high and continued through high school, much like I did, but I played clarinet and sax. I was proud of her following in my footsteps, and I knew that playing in band helped her establish a common support group. She took her marching seriously and took pride playing in band. Jessica enjoyed playing the piano, as I did, and she soon discovered the fake books with the chorus and melody line and was able to play a lot of musical pieces without the typical memorization most students do. She also played on the water polo team since she was always comfortable with water, and during summer she would always swim in our pool and at times put on a scuba weight belt to run along the bottom to the shallow end as if she were an old-fashioned deep-sea diver. If she got in trouble, she knew how to quickly release the weight belt. She was so good she never had to do that. Jessica also enjoyed Old English Shakespeare-style acting. All these activities at school gave her access to multiple teammates, though she never really had bonded close friendships that she desired most. She was overweight and would tend to try too hard to foster good, long-lasting friendships. She and I had tended to foster good, long-lasting friendship. However, I was still her concerned parent as well. We enjoyed riding our bikes together. At the beach, she and I enjoyed our time body surfing and challenging each other to the longest ride. Throwing the frisbee was also a great pastime. While Jessica was in college, I thought it would be great for her and I to buy annual passes for Six Flags Magic Mountain, since we both enjoyed the thrill of riding roller coasters. She was still in the latter stages of her extended adolescence, as I mentioned earlier. She was hesitant to let me know she was having a great time with me. We struggled together, but in the end it turned out to be one of the best times we ever had. We rode the new roller coaster X, which began with a chain drive UP leading to a wild, unexpected backflip, and continued to scare the heck out of both of us. When it was done, we couldn't believe that such a roller coaster could exist, and bought the coaster's action photo. I was glad to have bought the picture, especially since we never had the guts to ride it again. I still cherish that one picture of us to this day. She was becoming the fun-loving daughter I had remembered in her early years once again. There was finally light at the end of the tunnel, and my daughter was coming out of her adolescent stage. I love all my daughters very much, and I've always tried to guide them in the right direction as any parent would. To see Jessica in the predicament she currently has makes me extremely sad. We had lots of plans for the future, and I'm going to miss not being able to do them. My parents were planning for Jessica to help them in their old age, especially with her CNA experience. My mother died this past May, and my father is now struggling at the age of 85 at home. He doesn't want to hire a CNA person to stay with him. He wanted Jessica to stay with him in his last years because he knew he could trust her. I will always love my daughter Jessica, and we had many plans for the future. You see, I had been working with Jessica to forget about helping out her so-called friends by paying their mortgage. I knew in my mind anyway that that relationship was going to fail. I suggested she save her money instead and get back to her own life, and I tried to reassure her that we were her true, unconditional family. In fact, her sisters and mother were doing also the same thing, and we were actually starting to make good progress. We always told her we loved and cared for her. This adult child of mine, who was always looking for acceptance and friendship in others, was finally realizing that she already had that caring, concern, unconditional love and friendship from her one and only true family.
Thank you, Ms. Osby. Counsel, is the matter submitted?
Yes.
Pursuant to Penal Code Section 1168(b), as relates to counts 1 and 4, the court imposes the following terms to count 1 with a special allegation, a special circumstance, life without the possibility of parole. Consecutive to that term is to count 4, the court imposes life. I impose consecutive terms, taking into account California Rules of Court Rule 4.425(a)(2), given that separate acts of violence and crimes of violence were perpetrated by the defendant. The total indeterminate sentencing law term is 1 term of life without possibility of parole plus 1 term of life. Pursuant to Penal Code Section 1170 and 1170.1, the determinate term is as follows: is to count 3, impose a stayed term, taking into account Penal Code Section 654. That stayed term is to count 3 is the 8-year upper term. I impose, as relates to count 5, a term of 2 years, which is the upper term, as to count 5. As relates to the aggravated upper term, I take into account the following rules: Rule 4.421(a)(1), 4.421 paren A paren 8, 4.421 paren B paren 1. Balanced against any mitigating factors, they outweigh any mitigators, thus the aggravated term. Again, count 3 stay, count 5 imposed. The total term in this case is as follows: 2 years, taking into account credits of 1,312 days plus 1 term of life without possibility of parole plus 1 term of life. No credits as relates to the life term and life terms imposed by the court. With regard to the issue of restitution, we have additional restitution issues to resolve, and I believe we set the matter for hearing next week for that purpose. We'll confirm that hearing with other counsel present. Presently, the court imposes a restitution fine pursuant to Penal Code Section 1202.4b in the sum of $10,000. The court security fee is $160. The ICNA fee $120. The Criminal Justice Administration fee is $154. The sex registration fee pursuant to 290.3 of the Penal Code is $300. Restitution reserved at this time. Any restitution ultimately ordered will be joint and several. I reserve jurisdiction over the issue of restitution as well. All fines, fees, and restitution, if applicable, to be paid forthwith or is provided in 28.5.5. As relates to your client's presence at any future hearing, counsel, if you wish to be present at any restitution hearing.
Your Honor, I spoke with my client. She wishes to be present for the next hearing on the 15th, and after that she wishes to waive her presence and is asking the court to recommend CIW.
All right, very good. So recommended. DNA testing required pursuant to Penal Code Section 296, and registration pursuant to Penal Code Section 290 is required as well. And we'll address the waiver at the next court hearing. Anything more on behalf of the people?
Under the court, inform her of her appellate.
I'll do that at the next hearing. We'll address with each defendant their additional rights thereafter. And for the time being, she does understand, does she not, Ms. Osby, that she has a right to appeal within 60 days of today's date, that she'll be required to keep appellate authorities advised as to her location in the correctional system, and that counsel will be appointed for her unless she retains her own counsel. But any appeal must be filed within 60 days. She understands that?
She does.
Is that right, ma'am?
Yes.
Okay, and we'll address that further on our next court hearing date. We'll see what's back here next Friday. Mr. Espinoza?
I believe Mr. Wong.
Mr. Wong?
I just wanted to clarify for next Friday, is that a restitution status hearing? Because I believe I've been in contact with both victims, and I believe only the rest will be seeking restitution. If I can get that information to defense and we can stipulate to that, I don't know if we'll need an evidentiary hearing, but I just wanted to confirm.
The purpose to be served is a restitution review, and if in fact a formal hearing is required, why then we'll set a separate date.
Okay.
I don't expect that we'll, as a matter of necessity, acquire any evidence on that date, but we will have our discussion with regard to the request being made. And I know that some documentation has been submitted that I've examined at least in part, but I'll hear from all counsel regarding whether they think a formal hearing is necessary.
Okay, thank you.
Anything more on behalf of the probation department?
I just wanted to provide you with updated custody credits of 1362.
1362 as applied to the determination. Ms. Osby, anything more?
No, thank you.
Thank you. Then we're in recess. On the restitution issue, let me talk with counsel for a moment.
Oh, we'll do that next time. Okay. Yes.
Yeah, that's what I was I was trying to get it by 10.
Because it'll be joint in several.
At the